Welcome back to Lawyer Stories. I'm Mark, and today I want to discuss a rather intriguing and somewhat time-sensitive situation that a client firm brought to our attention recently. It's a classic example of how even the best-laid estate plans can encounter unexpected complications when information isn't effectively communicated or managed. The core of the matter revolves around a woman, let's call her Sarah, who resides in a rather secluded area of Texas. Her story began quite innocently, as many significant legal discoveries do. Sarah was clearing out an old fireproof box, a common repository for important documents, when she stumbled upon a notarized will. This wasn't just any will, it belonged to a former neighbor who had passed away 7 years prior. What made this discovery particularly striking was the content of the will itself. It explicitly stated that the neighbor's entire estate, including her land, her house, and all her assets, was to be bequeathed to Sarah's husband. Crucially, the will included a contingency. If her husband predeceased the neighbor, everything would then pass directly to Sarah. The timeline here is critical. Sarah's husband had passed away 10 years ago, meaning he died 3 years before the neighbor. Thus, according to the will's provisions, Sarah was the rightful beneficiary. Naturally, Sarah was bewildered. No one had ever contacted her regarding this inheritance. The neighbor, we learned, was significantly older than Sarah and her husband, had no children, and no other immediate family members who might have been aware of her affairs. Sarah's husband had a close relationship with the neighbor, often assisting her with her cattle and managing her pastures, which perhaps explains the neighbor's generous disposition. The will also named Sarah's husband as the sole executor of the estate, with Sarah herself designated as the successor executor in the event of his passing. The immediate questions, understandably, were twofold. Why was she never contacted, and could a will discovered so many years later still be considered valid? When the client firm initially approached us for guidance on Sarah's behalf, our first step was to help them understand the intricate legal landscape they were navigating. The lack of contact, while distressing, is unfortunately not uncommon. There's no central registry or governmental agency tasked with notifying beneficiaries or ensuring wills are probated. The responsibility to initiate probate lies squarely with the named executor, or, if none is available or known, with the next of kin. In this case, with Sarah's husband having passed and Sarah being unaware of her role as successor executor until now, the estate may simply have languished, or worse, been handled as if the neighbor died without a will at all. This brings us to the most significant hurdle, the passage of time. In Texas, where this case is situated, there is generally a 4-year statute of limitations to probate a will after the testator's death. 7 years have, of course, long since passed. This doesn't automatically extinguish Sarah's claim, but it does significantly complicate matters. Texas law does allow for exceptions to this 4-year rule, particularly if the party seeking to probate the will can demonstrate good cause for the delay. Sarah's late discovery of the will, arguably due to her husband placing it in a secure box without her explicit knowledge before his own death, presents a plausible argument for such an exception. The court would need to be convinced that the delay was not due to negligence or a lack of diligence on her part. Our initial analysis identified several possible scenarios that could explain the current state of the neighbor's estate, each carrying its own set of challenges. Firstly, and perhaps most simply, the will Sarah found might not be the most recent. The neighbor could have executed a subsequent will, perhaps revoking the earlier one or making different provisions. Without knowing the date of the discovered will, we can't be certain, but it's a standard consideration in these situations. Secondly, if no other will was found or known, the estate may have been processed under the laws of intestacy. Given the neighbor had no children or close family, this would mean the estate would have been distributed to more distant relatives according to Texas's statutory heirship laws. If this occurred, Sarah would be facing a challenge to an already closed estate. Thirdly, the neighbour's assets themselves might have been significantly depleted. It's not uncommon, particularly with elderly individuals, for substantial portions of their estate to be consumed by long-term care costs, such as nursing home fees or Medicaid liens. Furthermore, if the property taxes on the land and house were not consistently paid, the property could have been subject to tax foreclosure, meaning it might no longer be part of the original estate. Public property records would be crucial in determining the current ownership and any outstanding tax issues. Another possibility, and one that requires careful investigation, involves the neighbour's off-and-on-again boyfriend. We know he was described as a known alcoholic and gambler and may have been living in her house. If he has been continuously occupying the property for a significant period without legal title, questions of adverse possession could arise. In Texas, this typically requires at least 10 years of open, notorious, and peaceable use of the land, coupled with other conditions. While 7 years have passed since the neighbour's death, determining the exact nature of his occupancy, if he is indeed still there, is paramount. His potential interest or lack thereof could significantly impact the path forward. It's also plausible he too may have passed away, leaving the property truly vacant or subject to a different informal occupancy. The steps Sarah should take, and for which the client firm sought our counsel, are critical and time-sensitive. Her initial move to contact the county courthouse was understandable, but it's vital to stress that courthouse personnel cannot provide legal advice. Her primary action now should be to formally engage a probate attorney specializing in Texas law. Our recommendations focused on a multi-pronged investigative approach. First, the attorney should immediately perform a thorough search of public records in the county where the neighbor resided. This includes checking the county clerk's office for any previously filed wills or probate proceedings concerning the neighbor's estate. It's crucial to ascertain if any * probate action was ever opened, and, if so, who was appointed as executor and what disposition was made of the assets. We also recommended checking the County Appraisal District website, a publicly accessible resource in Texas, to determine the current ownership of the land and house, review its sales and transfer history, and identify who has been responsible for paying property taxes over the last 7 years. This will provide an immediate indication of whether the property remains in the neighbor's name, has been transferred, or has been subject to foreclosure. Second, the attorney must investigate the physical status of the property. Given the rural location and the several miles distance between properties, Sarah's family hasn't been consistently monitoring the house. It's imperative to determine if the off-and-on-again boyfriend or anyone else is currently occupying the house and land. This physical inspection, combined with property records, will clarify potential adverse possession claims or simply illegal occupancy that would require formal eviction proceedings. Once this initial research is complete, the legal strategy can be refined. If no probate was ever opened, Sarah, as the named successor executor, would petition the probate court to admit the newly discovered will to probate. This petition would necessarily include a compelling explanation for the delay, arguing that her late discovery constitutes good cause. The argument would center on her lack of knowledge about the will's existence, particularly given her husband's earlier death and the circumstances surrounding the will's storage in their personal fireproof box. If, however, a probate was opened and the estate was settled, either under a different will or as an intestate estate, the path becomes more challenging. Sarah would then need to initiate proceedings to set aside or challenge that previous probate order, presenting her discovered will as the valid last testament. This would likely involve notifying all parties who previously benefited from the estate, who might then become adversarial. A crucial consideration throughout this process is the potential for litigation. Any attempt to probate a will 7 years after the decedent's death, especially if other parties have already established interests in the property, is likely to be met with resistance. The court will scrutinize Sarah's claims of late discovery very carefully. The value of the estate must also be weighed against the potential costs and time investment of a protracted legal battle. In conclusion, this case underscores a fundamental principle in estate planning. Simply drafting a will is not enough. Ensuring that key individuals, executors, beneficiaries, or trusted family members are aware of the will's existence and location is equally vital. While Sarah faces an uphill battle due to the considerable passage of time, the specific circumstances of her late discovery, coupled with the details within the will naming her as both beneficiary and successor executor, provide a legitimate basis for pursuing this matter. The key now is swift, well-informed legal action to ascertain the current state of the estate and present the strongest possible case for the will's admission to probate. That's all for this episode of Lawyer Stories. Join us next time for another look into the fascinating world of law.